Good day. My name is Christopher Eukins. I'm the Lynn David Research Professor in Government Procurement Law at George Washington University Law School. Thank you for joining this, the latest in a series of webinars on procurement law and policy. I'm very happy to say we have 246 registrants for our program today from 43 countries and from 5 continents. Thank you all very much for joining us. The purpose of today's program is to help build a bridge between the European and U.S. procurement law communities regarding the vital question of defense procurement. Our webinar on October 18th, which focused on European perspectives, is on publicprocurementinternational.com and the GW Law Government Procurement Law YouTube site. Today's panel will focus on U.S. defense procurement with perspectives from around the world. The recording of this program will be available on that YouTube page for the GW Law Government Procurement Law program and also on the program page at publicprocurementinternational.com. During the course of today's program, please use the chat rather than the Q&A. We found that the chat is a good way of exchanging ideas. Our panelists will be monitoring the chat and will give citations to useful resources as we go. I should emphasize, because we have folks from all walks of life today, I should emphasize that the panelist statements are all in their personal capacities. The goal of today's session is to identify key legal issues in U.S. defense procurement, especially in light of the war in Ukraine, and want to extend a special welcome to our colleagues from Ukraine who are joining us today. Just get a little background. What's kind of funny about, interesting about the current defense buildup is that U.S. weapons exports had actually decreased 21% in fiscal year 2021. So that just before Russia's invasion of Ukraine, there actually had been a dip in U.S. exports of weapons. And of course, that has turned around a great deal very rapidly after the Russian invasion of Ukraine. The United States has provided more than $20.3 billion in security assistance to Ukraine. I'm quoting here from a Congressional Research Service report. And has been doing so through various channels, including Presidential Drawdown Authority and through foreign military sales. We'll be discussing in more detail foreign military sales and how they in turn trigger issues, for example, in export controls. Ukraine has also used foreign military financing and, again, the FMS program. We are going to be talking about the issues that arise in the context of weapon sales in the United States, in cybersecurity, in foreign military sales, in various trade controls, so you can understand some of these key legal issues, so that the barriers, the legal barriers that might otherwise arise in defense trade can be addressed more rapidly in a cooperative manner across the Atlantic. I'm just going to go quickly through our panelists and moderators today. My co-moderator is Michael Boucher. He's King's Counsel at Monkton Chambers and a visiting professor at King's College London. He's one of the United Kingdom's foremost procurement lawyers and regularly represents agencies and contractors in some of the most important cases in the United Kingdom and the Republic of Ireland. He leads a master's program in public procurement at King's College, and he kindly regularly co-hosts these joint programs with GW Law School. Chuck Blanchard of Arnold & Porter in Washington, D.C., previously served as the General Counsel of the Army and of the Air Force. He works with clients in the contracting and national security communities, drawing upon his experience in government and private practice, providing unique insights into doing business with the federal government. He represents major U.S. and foreign defense and aerospace companies on a wide range of national security and government contracts issues. This is including advising companies on the unique issues raised in acquiring companies that do highly classified work for the government, CFIUS, and Global Foreign Investment Review advice. This is what he'll be focusing on in our program today, and advice on compliance with U.S. government cybersecurity and supply chain requirements. Larry Bowles is the Director of Industrial Participation and Offsets at Teledyne FLIR. He works in developing global strategic partnerships and industrial participation strategies across all of the company's divisions, managing all global offset obligations, and maintaining a broad network in the international business community for industrial offset project generation and joint venture formation. He's also the president of Offsets and Global Partnering Consultants, LLC, which delivers industrial partnering solutions and strategies for aerospace and defense clients. He previously worked on offsets with other leading U.S. defense companies, including what was then Harris Corporation, Northrop Grumman, UTC Aerospace Systems, and Raytheon. Alan Green has over 40 years of experience experience, and he's engaged in extensive litigation and counseling on a wide range of international matters. He's represented clients in international arbitration and court litigation, focusing on those related to international government contracts and/or sovereign parties. He's worked on all aspects of international government contracting over the years, including foreign military sales, direct FMS sales, and USAID contracts and regulations. And he co-teaches the course with me at GW Law School, Foreign Government Contracting course, which is based on his book, International Government Contract Law, published by Thomson Reuters. And just a kind aside to Alan, he makes that book available on Westlaw, so our students do not have to pay for the book. We are continually grateful for that. Pete Growley is the director at Crowell & Mooring International Southeast Asia Regional Office. Drawing from over a decade of experience as a practicing attorney in the United States, Kate helps her clients navigate and shape the policy and regulatory environment for some of the most complex data issues facing multinational companies, including cybersecurity, privacy, and digital transformation. Kate will be focusing on cybersecurity issues with us today. Prior to joining CMI, Kate was a leading member of Crowell & Mooring's Privacy and Cybersecurity Group with a robust practice focused on the U.S. government contracting community, particularly those working with the Defense Department. Marcus Peterson is the managing partner of Pillsbury's Washington, D.C. office. His practice focuses on counseling and representing aerospace and defense civil contractors in both federal procurement and international defense sales. He regularly counsels clients on a wide array of government contracts compliance issues, including anti-corruption issues and mandatory disclosure requirements. He has a bachelor's degree from the University of Kansas and received his JD from GW Law School in our program. Maureen Romero is a senior counsel at L3 Harris Technologies. She previously served as senior counsel for CGI Federal, handled trade control issues for the Global Trade Group, and was a senior counsel at Raytheon, where she worked on a broad range of international defense initiatives. She serves as director and trade counsel at L3 Harris and regularly works on complex issues of export control compliance, which is what she'll be focusing on today, in their international markets. She received her bachelor's and law degrees from the University of Arizona. Dan Shaney is a judge advocate in the U.S. Air Force, where he is lieutenant colonel. He has had postings around the world with the Air Force as a lawyer and currently serves as the chief acquisition law at the Air Force Materiel Command at Wright-Patterson Air Force Base. He teaches as a lecturer at GW Law School and at King's College London, and regularly joins on our academic programs at GW Law School. He has a PhD from the University of Nottingham, a master's degrees in law from both GW Law School and the University of Nottingham, a master's in philosophy from the University of Iowa, JD from the University of Iowa, and a bachelor's degree from Brigham Young University. Clearly, Dan is the best educated person today. Thank you very much for joining us. And just full disclosure, Dan and I are actually just a few feet away from each other in Charleston. We're attending a conference together. So thank you all for joining us. With that, I'm going to open the floor to comments from my co-moderator, Michael Boucher.
Thank you, Chris. Well, welcome everyone. It's always a great pleasure to host these events. And I would say for those in Europe, this is a very important opportunity for us to learn what is going on, has been going on recently in the US. Defense procurement law has been a somewhat odd little backwater amongst the procurement law community in Europe. It's always a sort of surprise, I think, to Europeans when we come to the federal procurement events in the US and we see that the defense procurement is so much at the heart of people's thinking around procurement law, government contracts law in the US. Quite the reverse is true. Those of us who do in Europe and the UK, for those of us who do defense procurement work, it's something one does sort of just with those people who deal with that area of law. I think that was certainly beginning to change in the UK because one of the things we are going to do post-Brexit is start to reform our defence procurement law. That is leading to already to some significant overhauls in the way in which we deal with matters. And I think one of the important things for me is just to really to learn what's happening. Thank you.
Thank you very much. I could turn it over to Alan.
Hello, everyone. Very happy to be here, and thanks for joining us. In terms of historical precedents, as we see for legal cooperation, as we all know, the issue facing us today historically has been the same: isolationism, as far as the United States is concerned, and European countries. Isolationism versus engagement. And I think the good news is that there is a continuing and historically developed framework of many kinds of cooperation between the United States and Europe, in particular the European major defense manufacturers and governments involved. That cooperation we see going back hundreds of years, international cooperation and financing, letters of credit and so forth. There is a framework for recognition around the world and of international arbitration awards and for conducting international commercial arbitrations, many of them, in my experience, certainly involving US contractors and foreign ministries of defense and vice versa. There's been cooperation between the United States and Europe as a result of the Cold War, as we called it, in export controls vis-a-vis countries we were worried about exporting to them. There's a framework for arbitrations under treaties to protect investments in foreign countries that will occasionally involve defense matters. And there has been, very importantly, a long history since the 70s of co-production on major defense programs between United States companies and European companies. For example, the co-production of the F-16, which on goes to this day. That co-production has created a framework of understanding between the Department of Defense in the United States and the ministries of defense in Europe, of understanding how the procurements are going to work, of working them jointly, and of creating then supportability and fungibility between parts and so forth between those countries. And of course, then we see the formation after the Second World War, when we were engaged, as opposed to after the First World War, when the United States retreated, with the Marshall Plan, the Lend-Lease Act, and of course, the formation and continuing progress of NATO. So I think this is an exciting time because once again, we're seeing, and we'll certainly see with elections in the United States as they finalize, tension between whether we're going to isolate ourselves again in the United States or continue to engage, in pertinent part, of course, vis-a-vis the situation in Ukraine. Chris?
Thanks so much, Alan. I wonder, Dan, if you could just say a few words about some of the international agreements that have helped frame this sort of transatlantic cooperation that Alan was alluding to.
Yeah, no, that's exactly where I was going to go. Thank you for the very kind introduction. I may be the most educated on the panel, but I think somehow I'm the least qualified. So I'm very grateful to be here with this panel. I first of all, before I get to the international agreements that Alan mentioned, I just wanted to say the good news is that from the classic book, I'm sure everybody in this webinar is familiar with, Fortresses and Icebergs. Up at the prime level, there's a separation between Europe and America, but down at the subcontractor level, beneath the surface, what the authors of that book say is that there's a huge, they're deeply connected, the supply chains at that level. But there are more opportunities for robust competition in the defense market, and I think that we ought to be doing more of that with our European allies. In that same volume, Fortresses and Icebergs, the authors talk about how Europe is really good at delivering 70% solutions at a fraction of the price. And I think that's something that we ought to be looking at more in the Department of Defense, is those 70% solutions that aren't as expensive as our gold-plated weapon systems. Martin Seif in 2008 wrote an article called "Europe Can Offer Deals That Washington Can't Refuse." And he uses the example of a diesel-electric submarine. This is outdated, of course, but a diesel-electric submarine that was built by France and Germany and Sweden that would be very competitive and much cheaper than the American solutions. And Sophie de Veckerboy, a French author, in 2008 also, she has a nice table in her article. I'll link to all these in the chat in a minute. But she talks about all the different weapon systems that we rely on Europeans for. The Abrams tank has a German cannon and uses British armor. The Stryker armored vehicle was designed by the Swiss. The president's helicopter, this is all outdated, but at that time was going to be an Italian helicopter. The F-35 Joint Strike Fighter flies with a British engine technology. So there's a lot of connection there, and there are opportunities there for the U.S. to benefit from those 70% solutions overseas. Now, back to your question, Chris, what are those trade agreements, or what are the provisions that make it possible to increase the amount of trade and competition between the U.S. and Europe? And one of those is the reciprocal defense procurement agreements that are embedded in the DFARS. And I'll link to that also in the chat here in a minute. But basically for what are called qualified countries, the Buy American provisions and all the other protectionist things that we have in place don't apply. And I did a quick count. There's a website for this. I can link to this also, but there are 22 countries in Europe that are qualified countries. So my guess is that's pretty much every country in the EU that has a defense industry, or maybe some of the smaller countries like Liechtenstein aren't in there, but every country that has a defense business, they're already one of these qualified countries. So reciprocal defense procurement agreements are a huge way to expand trade. Something else, Chris, that maybe you weren't thinking about, but I'm playing around with this idea. The former Undersecretary of Defense and Acquisition, or Defense for Acquisition Sustainment, Ellen Lord, published something early this year, or made a comment, and it's shown up in the news. But national technology and industrial base countries, right now, Canada has been part of that since 1994. The UK and Australia joined in 2016. I can't help wondering if that would be something that could be expanded to our European partners also, that would again create more opportunities for competition from Europe and open up our markets and theirs to more cooperation. So that would be my answer: reciprocal defense procurement agreements, and possibly the NCIB, expanding that to our European friends and allies. So thank you very much.
Thanks, that was very helpful. And just to expand on that last point that you were making, the Canadian Commercial Corporation is a crown corporation, the Canadian government, that actually serves as a front end for Canadian defense manufacturers selling into the U.S. Defense Department. So that would be an extension of your idea that to have a government entity in Europe that could serve as a front end for European producers selling into the Defense Department, much like the Canadian Commercial Corporation does. The Canadian Commercial Corporation really takes over the management of those contracts in a very, very interesting way. Okay, so let me pass it on then to Chuck. The floor is yours, Chuck.
Great. I'm going to talk about technology and acquisition controls that are used mainly in a very aggressive way against China and Russia. You're going to hear a great presentation about export control that more likely would apply to transfers from the United States to Europe, including Ukraine. But my focus is going to be really different about efforts that the United States has taken to try to maintain its technological edge. And by way of background, in the last decade, there's been growing concern about how China is gaining a technological edge, and doing so through commercial transactions with United States companies, including acquisitions, joint ventures, technology transfers. And that has led to some significant reforms, the most significant of which was a great expansion of foreign investment review by the Committee on Foreign Investment in the United States, with CFIUS, and also a more aggressive use of existing authorities that the Department of Commerce has in its export control. So just a brief first on CFIUS. CFIUS is the regulatory system that's used by the United States to review foreign investment in the United States. And it used to only be focused on control transactions where a foreign buyer was taking control of a company. But in response to concerns about China using its minority investment authority to get around CFIUS and still get access to US technology, Congress recently strengthened the law. And the major changes were, one, to expand the CFIUS authority to minority investments when there is a danger of giving a foreign party access to critical technology, personal information, or critical infrastructure. And second, for transactions that involve critical technology, CFIUS now requires mandatory filings. It's no longer voluntary. And the result has been a large increase in filings with CFIUS, a reticence by Chinese companies to even make investments in the United States, although that is still occurring, and a more aggressive look back by CFIUS. CFIUS is now looking back at transactions that occurred years ago, but for which there was no CFIUS filing. And they are asking the parties to file a CFIUS notice. And in some cases, they're actually undoing transactions that occurred in the past. And the result has been that Chinese and Russian companies have really not been allowed to invest in certain sensitive US companies. There's still a significant amount of Chinese money coming into the United States, but it's going through CFIUS, and there are mitigation efforts to ensure the technology that's sensitive is not coming to the United States. The good news is, at least for Europe and UK companies and Canadian companies, CFIUS has been fairly reasonable in its review of transactions, recognizing that the threat really isn't there. So I'll go to the next slide. The other tool that has been pretty profound in the Ukraine conflict and is also being used aggressively against China is the use of what I would say export control as sanctions, or export control that's more directive than what Lori will talk to you about, that's more applicable to routine kind of transactions. Commerce has long had an authority called the entity list, where they can place organizations on the list that they believe present a threat to the national security of the United States. And any technology that's going to that company, even a pencil, even laundry services, would require a license to export the technology or the product to any entity in the entity list. And traditionally, it was used for companies that were closely tied to the Chinese military or the Russian military. It's recently been expanded, however, pretty aggressively. The other authority that Commerce has begun to really force is it's adopted a foreign direct product rule. And under this rule, even a foreign produced item that's created, located outside the United States is still subject to US control rules if it's a product of control technology. So for example, if there's a transfer of US technology that to a foreign entity so they can make semiconductors, those semiconductor, even though the semiconductors themselves are made in Taiwan, export of that is controlled if it's sent beyond Taiwan to other countries. And this is fairly powerful, and I'll describe how it's been used. A few years ago, both of these tools, the entity list and the foreign direct product rule, were aggressively used against Chinese telecommunication firms, including Huawei. And the effect was pretty dramatic. Huawei, which was a leading player in 5G, saw its market share reduce. It was less able to compete. And as a result of the success by efforts against Huawei, the Commerce Department and the United States government recognized it had a pretty powerful tool. So let's talk about what's happening in Ukraine. First, these enhanced export controls have been used very effectively against Russia. Now, traditional sanctions, which are more financial in effort, both the regular sanctions laws that the United States has long had, and also some more recent legislation that Congress passed during the Trump years. Those financial sanctions, are being used very effectively, but these enhanced export controls probably are even more powerful. They've been applied against semiconductors, the oil industry, computers, lasers, the aerospace sector. And the United States has effectively cut off all Russian airlines, for example, and most Russian oil companies from US technology, which has made it very difficult for Russia to continue to use that technology. There have been workarounds. There's some evidence of some efforts that are to get semiconductors from other products into Russia, cannibalizing consumer products and using the chips in them for weapons. But effectively, it's reduced the ability of many sectors of the Russian economy to use U.S. technology. And then more recently, these tools have been used against China with a focus on high-end semiconductor technology. Recently, some new export controls have been applied to the semiconductor technology, and using the foreign direct product rule, very high-end semiconductors, even if they're made overseas, are subject to US restrictions and can't be exported to China. And the goal here is to have more routine semiconductor continue to be exported, but the more exquisite semiconductor technology, such as that would apply to an AI or supercomputing applications would not be available. And the goal here is to go beyond the entity list that really only focus on companies with a close tie to the Chinese economy and expand it more broadly so that any company in China would not have the ability to receive this technology. So the short end of this is that, I guess short summary is that there's been an increased focus on protection of US technology. It's been focused on specific countries such as China and Russia. And the foreign direct product rule has been the most effective tool available, because a lot of US technology that's used abroad can be applied to prevent even products produced abroad from being exported to Russia and China.
Thank you very much, Chuck. I'll turn that over to Larry.
Okay, thank you, and thank you for the opportunity today. I'm going to address some really observations about what's going on with us U.S. defense companies in Europe in particular when it comes to offsets. So just to make sure we're all on the same page of what offsets are these contractual, reciprocal industrial relationships that happen between a procuring government that's buying defense items and contractors. So basically a jobs program, if you will, where the procuring government, as they're spending lots of their taxpayer money, wants to make sure that some jobs are set aside for industry or the military, but usually industry in their country. So as defense contractors around the world, we have to deal with these requirements, very frequently around the world. And really, when it comes to Europe, the framework in terms of a reference in time is really the 2009-2011 period, where the Defense and Security Procurement Directive 2009-81 EC came into being, which basically banned offset from the procurement process of within European defense procurement. Never used the word offset within the directive, but the concept was there. They allowed within the directive to have any country invoke an exception using Article 346 of the Treaty for the Functioning of the EU, which enabled them to circumvent the Defense Procurement Directive and do things like get offset if it was in the country's national security interest. And that the interpretation of that is that, all right, fine, if it's national security interest, then it really needs to be directly, the offsets need to be directly related to what it is they're buying. So what we would actually in the business here call direct offsets. In other words, if they're buying rocket launchers, anything that's related to the rocket launcher would be considered direct. Anything else, like say for instance, we're buying stuff from suppliers in that country, but it's not related to the rocket launchers, that would be indirect. So really, the ability to do indirect kind of disappeared when the Defense Procurement Directive came into being and was enacted by all the member states in 2011. So really, since then, we've been monitoring the cases, because anytime a country wanted to invoke or did invoke Article 346 and asked for offset, they were always under the threat, really, of being pulled into Brussels to defend that stance to the European Court of Justice, ECJ, sorry. And so we've been monitoring these cases. It's happened for a handful of countries, and really, it's always been the threat of Russia, attacking that has been the basis of why any country would feel it's in the national security interest to do to ask for offset. And so the effect of that really is that it has the ability to slow down the procurements. That every country had to, in these cases where they had to defend, extra red tape, extra time. But at the end of the day, they couldn't do anything like create a new blanket regulation for the country saying, we're going to always do this. It's always going to be a case by case type of a basis. So really, I think what we're seeing now that the Russia aggression is actually happening and is much more of a concern than even it was back in 2014 when they first invaded. We are still seeing the imposition of offset requirements a little bit more commonly. You also have to look at, in practice, the balance between them asking for offsets and the quickness of being able to field whatever it is that they're buying. So yes, we think that there'll be an increase in requests for offset requirements within each of these individual procurements. But offset does slow things down. I think the U.S. Air Force several years ago did an analysis, and any FMS case that had an offset requirement slowed the procurement down by 18 months. And so that, extrapolating that, going forward here, if there's an immediate need, asking for offsets is counterbalancing the ability to field what it is they're doing, because again, we have to qualify suppliers, move production into the country, teach them how to do particular aspects of whatever it is that they've asked to do. And so really that's it. I think the other thing too that we're monitoring is just the effect of the European Defence Fund and the Permanent Structured Cooperation, PESCO, with these multi-member state cooperative efforts, and whether that would have an effect on offset per se, because when there's a PESCO project, we are talking about directing work into a particular country, which is kind of going counter to what the Defense Procurement Directive was originally created to do. So that's it for me. So pass it on. Thank you.
Thanks very much, Larry. Yesterday we had a lecture for Alan and I, and for our class, we had a lecture from Andreas Sundstrand, who's a professor at Stockholm University. And she described for our students what you described, which is that it's concentric circles of regulation in European defense. The inner circle is the things that are most imperative for national security under Article 346. Then you have the 2009 directive, and things that don't really relate to defense, like pencils that are being bought by an army, would be covered by the directive in general. And I put to her this question that you raised, which is, if an issue of immediate national defense, such as the Russian aggression, does that fall within Article 346, so that offsets, which would normally be prohibited by the 2009 Defense Directive, is there a tenable argument there? And she wasn't sure. If you were arguing this in Brussels, Larry, and you were arguing to Brussels that a procurement really should be defense procurement today that relates to the Russian aggression really should fall within Article 346, and therefore offsets should not be prohibited because it doesn't fall within that ring of the 2009 directive. Could you point to historical examples where nations have been able to use offsets to build up their own defense capability?
Well, yes. In terms of, there's almost every case of offsets, there's been technology transfers, and trainings and things like that. Western Europe has a much more mature defense base. It's always been for the last 20, 30 years, just kind of keeping up with the US. If they're a lot of cases able to do their own, make their own equipment, and it's pretty close. So anything they're having to buy from the outside, they're just a little bit behind. So being able to keep up with us, so there's, you go to any of these factories in any of these countries, and you can see how close they are to what we're doing, and how offset has been able to keep the gap closed. When it comes to the Article 346, the case history, it depends on which side you look. When I read the legal briefings, and it looks like the EU wins. You talk to the countries and then the people, and it's like, no, we got what we wanted after all, so we won. So to me, that's an interesting situation.
Thanks very much, Larry. Michael, I think you had a comment.
Just to say that I think, having dealt with this a few times now in the last few months, I think the correct legal label, if you're going to rely upon the urgency of the invasion, you're actually relying on emergency powers, which are analogous to those which were much litigated around the pandemic. That's how you get out of jail, as it were, on offsets of anything. As it were, the correctly, and as has been said, we in fact, what actually happens and what the law requires is not necessarily the same thing. Sorry, that's not quite what to say, but that's what I'm saying, because what people get out of these cases can be different. But the thing about Article 346 is it is relied upon by Western European countries historically as very much defending a local production requirement. So, for example, the UK and France always relied upon Article 346 for warship production because they need to keep their shipyards going. Germany didn't worry so much. So it's the same procurement might in Germany not be 346 because they just don't worry about keeping their naval shipyards, their naval shipyards going.
Yeah, and basically, like, I'm at an offset conference now where we're kicking it around, and I think it really comes down to sovereignty, right? I mean, if you really need, the offsets because it's your national security interest, who's the ECJ to overrule that? So I think that was the consensus of the folks I was talking to about it.
Thanks so much, Larry. Just note, thanks to Larry, we posted Dan Shaney's article on offsets that he published a few years ago through the Air Force. We posted that on the program page as well. Thank you. So, Kate, I'll turn it over to you in Hong Kong.
Thank you so much. So apologies if folks have seen me yawning a couple of times. It is definitely not the content. It's just because it's a little late over here. So I'm nevertheless delighted to be here and to chat a little bit about what I think is one of the most interesting challenges in procurement right now, and that's cybersecurity. And with respect to Ukraine, it's been really interesting to see how those developments have prompted the Department of Defense here in the US. I say here, I'm still my brain still thinks I'm in the US, but the Department of Defense within the US to really double down on the importance of its international partners and the contracting community that those international partners rely on. And oftentimes in those conversations, we've sort of seen DoD officials make the rounds with international meetings really pressing this. And at the heart of that conversation is cybersecurity. And the DoD's expectation that if we need to rely on you, we need to know that we can do that with confidence. And cybersecurity is at the core of that assumption. So what we wanted to do here with the short time that we have is really set the stage. Quickly call out some of the key issues that we know here in the US, public sector customers, and in particular the DoD, are really wrestling with, and how those issues are being addressed. So that way folks in other jurisdictions looking for opportunities to partner with the Department of Defense in particular will understand where that customer is coming from because they will have the same expectations of you. So first issue, the really basic question of whether cyber should be foundational or whether it should be one of many factors that traditionally get weighed when you're evaluating bids. So historically, you're talking about things like schedule, cost, and performance. And different customers in different contexts have weighed those factors differently. And up until recently, the US has considered cyber to really be on par with those other negotiable factors. But the DoD in particular has really shifted their approach and has started to treat at least some degree of cyber as non-negotiable. And the rationale is that, look, it doesn't matter how cheap something was, how fast I got it, that doesn't count for much if what I got is vulnerable to a cyber attack and compromises my ability to use it the way I intended to. Another common pain point, the question of how to manage cyber down the supply chain. And this typically comes in two flavors. So the first is the question of who should be responsible for managing the supply chain question. Is it the government that should be taking the lead and vetting the cybersecurity of each and every tier, which can be a lengthy list in a lot of these programs? Or is that task better delegated to the prime, and the prime then ultimately becomes responsible to the government for the performance of its subs? And here too, particularly with the DoD, we're seeing more and more instances where the government takes the latter approach and they really lean on their primes to illuminate a program supply chain. And a part of that thinking is that the primes are really better positioned to be that go-between, especially when it comes to resources. The other supply chain issue is how broad we're talking about here. Is this just subs, or does it also include vendors? Vendors have often lived in this kind of gray space when it comes to cyber flowdowns, but the DoD and the rest of the US government are really getting smarter and more deliberate about calling out the need for anyone who could be a threat vector. Whoever could be that weak link in the chain, they need to be cyber secure, even if they're not directly receiving government dollars under that contract. Last big issue that we wanted to flag here, this is certainly not an exhaustive list, continuous monitoring. So when it comes to assessing compliance, you typically have two options. You can either take a snapshot in time approach, this is how I stacked up at that moment, or you can take a more dynamic approach and require a continuous assessment process. Now, in theory, the continuous process is going to be much better at accurately assessing and then ensuring compliance. But something that the DoD has really struggled with is how to operationalize that dynamic approach, and particularly when it needs to be done at scale. And what you often see is that it's a lot harder in practice than it is in theory. If we can jump to the next slide, if we talked a little bit about what those common issues are, we also wanted to do a little bit on the current state of play, again, particularly with the DoD. So as we mentioned at the top, the US has shifted to a model where all contracts that implicate any kind of non-public information, they're going to require at least a basic level of cybersecurity. It doesn't matter if you're talking military or civilian, and it doesn't matter how sensitive the information actually is. If it's not otherwise available in the public domain, then you, the contractor, need to put in some effort to keep it that way. The DoD has taken it a few steps further and has standardized more advanced cybersecurity requirements for any DoD contractor that is handling qualitatively sensitive information. And the term that often gets used to describe that information is controlled unclassified information, or just CUI. And I will actually use this as an opportunity to quickly caveat that all of my comments here, we're not talking about classified information. That's a whole different ball of wax. We're not talking about the security of private clouds or the government's own networks. We're just talking about information that contractors are asked to handle on their own networks. That's the most common scenario that we see. And to be frank, we had to slice and dice this topic somehow, otherwise there wouldn't be any time for any other topic, as I'm sure the other panelists have had to do so as well. Anyway, so the DoD for almost a decade now has been relying on these standard contract terms that require their contractors to self-attest to meeting these more advanced cyber requirements. But recently, the DoD has been working through a process of rolling out a formal validation process that goes beyond just taking the contractor's word for it, and instead looks to third-party assessors, and in some cases, even the DoD itself, to go on site and confirm that the contractor has indeed implemented all of the required cyber controls itemized in the contract itself. That program that's being rolled out, that's called the Cybersecurity Maturity Model Certification, or just CMMC. If you've been tracking DoD cyber, there's no way you haven't heard this new 4-letter word. We can spend a whole nother hour talking about just that. Happy to take that discussion offline for anyone who's interested. But here, just to take a step back and bring it back to the international perspective, the DoD has historically been at the vanguard of US procurement cyber policy. And there are a lot of other US and foreign government customers who are really watching this to see how this CMMC experiment in particular unfolds. There are a lot of lessons to learn from the DoD's efforts. And here, there's been a lot of discussion about how the DoD is going to use CMMC with its foreign contracting base, its private sector partners that are outside of the US. And the issue of reciprocity keeps coming up. We've already talked about it a little bit here today. There are persisting concerns that foreign contractors are going to need to reinvent the wheel to demonstrate compliance with something like CMMC, even though they may already be complying with other foreign-based compliance standards. Excuse me, so that might be the UK Cyber Essentials. They might already be ISO certified. So whatever happens here with CMMC, that could set the groundwork for more or less international reciprocity, which has its own challenges, and again is another conversation. But for now, I'll wrap it up here. Happy, of course, to take questions either via the chat or offline. So I'll shoot it back to you, Chris.
Thanks very much, Kate. And just quickly before, and we're a little short on time, we'll go over time so that we can go to 1:15 or to 15 past the hour. So just a quick question for you. Do you think that this issue, this very important issue that you've raised regarding cybersecurity harmonization, do you think it'll be done through the Defense Department, through industry, or do you think the trade apparatus, like the U.S. Trade Representative, the trade agreements, under which pathway do you think the harmonization will occur? The industry, defense, or through the trade mechanisms?
I'll answer a slightly different question, and which mechanism I think is most likely to implement a harmonization scheme sooner rather than later. Now, whether or not it will actually happen, I think we'll have to wait and see how CMMC rolls out. But I do think that an industry-led effort is likely to be the most successful, because one of the things that we've seen with CMMC is that there has been this constant push and pull between the Department of Defense and industry, because the expectations of both sides of that transaction have just been a little off kilter. And so here, if we're going to get a harmonization effort, if it is led by industry, that's half the battle, in the sense that that's the audience that in many ways you're trying to satisfy, because it can become a market access issue. And as we were talking about all of the great procurement products and services that the European market can provide, if cybersecurity becomes a barrier to that, that's to everyone's detriment. So if something is led by industry who have the motivation, the resources, the sophistication, it will probably get done sooner. Now, that said, I think the trade aspect that needs to be a part of the dialogue, that needs to be sort of a tool in the toolbox. And obviously the economies need to be a part of the dialogue, because they're ultimately the ones who have to implement whatever mechanism that ultimately is proposed. So it needs to be a collaborative process, but I think it is most likely to happen if you have industry leading that process.
Excellent. Dan, you had a question?
Yeah, Kate, I guess my question is it working? All these new cybersecurity requirements, I can't help wondering sometimes if we're just crowding out the smaller defense contractors who can't afford all the compliance, and yet we're not any safer. I just wonder, it's a huge compliance burden, but I don't know if the DoD is any safer, or prime contractors, I should say.
Yeah, I think certainly the statistics about what you see with incident reporting and publicly known breaches, like that certainly makes the case that it's not working. There's also the argument that perhaps we just have greater awareness of it and greater visibility. The DoD's position is that, again, cybersecurity is foundational, and we are not in a position from a national security perspective to make the trade-off, even if it is for a particularly small, medium-sized business section of the defense industrial base. That said, they recognize exactly that challenge and have really strived to make the compliance apparatus flexible. It's supposed to be in many ways a one size fits all. You've seen an evolution in the way that they have articulated the exact cybersecurity requirements, where originally, when the DoD in particular put out their standardized cyber requirements, it was tied to a very prescriptive set of controls that many companies found really daunting to implement. And what the DoD did was work with NIST, the National Institute of Standards and Technology, and they created a brand new standard. It's called Special Publication 800-171. If anyone wants some good bedside reading material. But it is designed for any company of any size in any sector to be able to implement these performance-based requirements. So we don't care how you get there, and there's a lot of different ways that you can do it. You don't need all the fancy bells and whistles from a technical perspective. Sometimes just having a policy is sufficient, and that's something that any company can do. And so long as here's sort of the end state that you are in terms of what you are protecting against, and it's a risk-based decision, that's where I think the DoD is trying to strike that balance. Now, of course, the devil is always in the details, and you can see time and time again where well-intentioned efforts don't always translate into reality, but that's the balance I think that we're trying to see being struck, because it's a really tough nut to crack, because security can be hard, but it is also, again, from the DoD's perspective, it's non-negotiable now.
Thank you very much, Kate.
Thank you.
Now we're going to turn it over to Marcus to talk about foreign military sales.
Great. Thanks, Chris. And just at the onset, a big plug to Chris and the other moderators for this. One of the things I think is kind of just framing the issue with this slide is being able to get together with other procurement professionals on both sides of the Atlantic and globally, because I think having this kind of conversation makes things like that are happening in Ukraine right now, providing defense articles and defense services relatively smoothly, easier to do when you're having these conversations amongst professionals peer to peer. So thank you, Chris and Michael and Alan and the others. By way of background, this chart right here sort of is a 20-year sort of look back at foreign military sales by the U.S. To our allies. And you can see starting in the early 2000s, the numbers weren't, really eye-popping. And that sort of represented sort of the view of the world prior to, September 11th here in the United States, in which foreign sales were really the sort of cake, for many U.S. defense contractors, and it was the icing on the cake. And if you got some good sales, that was great, but it wasn't something that really necessarily was centered on the sort of revenue growth at the time. Having said that, though, as you can see from going into the middle of the decade, the prior decade, you saw a pretty big uptick in foreign military sales as the U.S. government sort of started to focus on some of the geopolitical risk that we were seeing, both with the rise of China, with Iran, North Korea, and Russia. So in 2020, the last year on this side here, we were at about $50 billion in FMS sales. Now, Chris mentioned that there was a dip last year, and that was a significant dip. It dipped to about $35 billion. And there are a host of reasons in 2021, excuse me. So there are a host of reasons that folks think that there was a dip. I mean, in part, there was COVID, which one of the things that I'll talk about here as sort of the program of the FMS process is there's often a very long lead time to get to an FMS sale in which there's back and forth discussions. There's contractors who are meeting with foreign officials. There are government officials, government to government meetings. And of course, we all know that COVID limited the ability for folks to travel and to meet and the like. And sort of ancillary to that, in fiscal year 2022, we saw our numbers rebound in the total sales, the foreign military sales, at $50 billion, a little over $50 billion. And all indications, in light of the things that are happening in Ukraine and the continued aggression of Russia and China and others, we expect that over the next several years, those numbers sort of hold steady. Chris, we can go to the next slide. So I'm going to try to touch on all of these issues. There are a bunch of issues here that sort of talk around and talk to the foreign military sales program. What we're talking about here is the U.S. government, in a nutshell, entering into government-to-government sales with a foreign Ministry of Defense. Now, Alan sort of set the background talking about security cooperation and how that's been for decades a key pillar of U.S. foreign policy. And he really sort of set the table, focusing on both the letters of credit issue and other aspects of security cooperation. In the defense aspect, we can look back to the Lend-Lease Act first with the United Kingdom and also with Russia as some of the during World War II as really foundational in the U.S. exporting defense articles and defense services. Security assistance is really what we're talking about, and those are subsets of programs that are articulated in Title 22 of the United States Code that allows the U.S. government to export defense articles and defense services. And so, and it's via the Foreign Military Sales Program, the Foreign Military Financing Program, and other security assistance programs. This foreign military sales process utilizes the Department of Defense's procurement system. So it's just, most of us here who are in outside counsel, we represent government contractors in their sales to the U.S. government. There's another step here. So in executing a foreign military sale case, there's often a series of discussions and backgrounds between our embassy officials in various countries and their military folks and other government personnel. There's marketing amongst our contractors, and there's really two agreements here. There's the government to government agreement, which is memorialized in what's called a letter of offer and acceptance. That letter of offer and acceptance contains all the terms in which the U.S. government is going to provide those defense articles or the defense services. One of the kind of key points here that historically the U.S. government has has desired to have that letter of offer and acceptance proceed on a total package approach. What that means is that instead of just, let's say country X wants an F-15, we just have the F-15 sent over, but none of the training, none of the supplies, none of the understanding of how to really operate, spares that need to be associated with the F-15, and really maintaining the F-15 through the life cycle of its use. That's not been a really good sort of long-term investment we've seen from the foreign military sales perspective. So we truly try to push on making sure that any FMS case is executed on a total package approach. Now, how does that defense article in that situation, the F-15, how is that provided? Well, there's a procurement contract that the U.S. government then executes with the contractor, and that procurement contract is executed mostly in line with any other U.S. government acquisition. Now, Larry talked a little bit about offsets here, and that is another issue. If you saw his chart, you would notice that the amount of offsets for many years was pretty close to the amount of the actual value of the FMS case. So you kind of have to be mindful of that too as you're working through this, because that will be another issue. And as Larry and I think Dan just mentioned, the issue there with offsets is that it can slow down the execution of an FMS case. And I'll touch on that in a key emerging issue here shortly. So some miscellaneous issues. So FMS cases, when they're sold, there are three ways of transporting transporting the items. There's through the U.S. systems, and then there are two foreign systems that you can transport the items. Although they're government-to-government agreements, there's often the need to secure export licenses, and that's often, that's often in part because there's a marketing aspect to here. So Company X and Company X are competing on the value of their product here, and so as a precursor to getting into the FMS case, they're going to want to meet with foreign officials and showcase their know-how. So you should be mindful that even though as in the main export licenses often are not needed for an FMS sale, you may need them at the onset. And importantly, if you have an offset agreement that has any sort of technology transfer or the like, you may need other licenses to execute those offsets that will be related. If there's, for example, a direct offset that's related to the FMS program. I should also just note, generally, there are a series of exemptions to the ITAR, to licensing requirements if you're exporting an item that's related to an FMS sale. So you should make sure you're looking at part 126 in the ITAR. Now, quickly on FMS violations, under the Arms Export Control Act, the president has delegated his authority, his or her authority to determine who's eligible. And so there are a series of factors that the United States goes through to discern who is an eligible purchaser of defense articles and defense services. One way to get that terminated is through violations of the in-use agreements. So as a provision of receiving defense articles and defense services, the foreign purchaser agrees to maintain the security as the way that the U.S. would, and they agree to certain in-use monitoring. The U.S. government has in-use monitoring programs. For FMS, it's Golden Century, and there unfortunately are times where violations do occur, and the privileges of receiving defense articles or defense services could cease or at least be suspended for a while. So that's at a high level foreign military sales. Again, it's really a two-party agreement. It's the government-to-government agreement, the letter of offer and acceptance, and then often a procurement contract. Before turning to direct commercial sales, though, I do want to touch on one thing as it relates to Ukraine, because Chris mentioned that many of the articles being provided to Ukraine have been through our presidential drawdown authority. That's also another aspect of the foreign military sales program and security assistance. And in a nutshell, what that is that's where the U.S. government is looking to, on an emergency basis, is saying, hey, country X needs this item on a rush basis, and so we're going to draw down on our stock. And so we're taking, for example, HIMARS and other things out of our inventory and providing them directly over to Ukraine. That's another ability. So instead of having the two-party agreement with the procurement contract, we're just taking it out of a stock sale. Now, one of the emerging issues that I'll touch on here is, and we've kind of heard this in the United States, a little bit of the chirping around our election that we just had, and some of the depletion of our defense hardware, is we have to replenish those stock. We have a lot of depletion in a variety of weapon systems, and so I expect that's going to be one of the reasons why we're going to see an uptick, I believe, in defense procurement coming up in the next few years. Just one quick plug on direct commercial sales. They are what they sort of sound like. That's where the U.S. government's not really involved in the contracting process. It's a commercial contract between the foreign purchaser and the U.S. contractor. The U.S. government, of course, is involved there because there needs to be an export license, and there are export licenses often at the very beginning. Again, with the marketing aspect, any exchange of technical data that's subject to that's controlled by the ITAR, and then obviously you'll need an export license in order to ship the defense article or perform the defense service. And again, just with foreign military sales program, where there's the country to country and then procurement contract, there are offsets that come into play with direct commercial sales. Now, some of the key emerging issues, you just heard from our colleagues on a bunch of them. I just touched on the replenishment of stock. I think Kate just hit cybersecurity. That is a huge issue that we're seeing. In fact, one of my clients had in Europe is a supplier to a U.S. contractor for the F-35, had a cyber incident. We had to rapidly report. It was an export control related thing. So we were reporting to two different agencies here in the United States, providing a disclosure. So that's an issue, because how our European allies, as we're continuing to partner up with them, how they protect our data is something that is going to be super important. Speed time. And this was alluded to here earlier with the sort of necessary sort of use of offsets related to all of these programs. It slows down the process. FMS sales are generally slow. And one of the things that both our allies and the US government is coming to terms with, we're just doing it too slow. So we need to figure out a way to speed the process up. There's a study undergoing right now by Secretary of Defense Lloyd Austin, who announced, I believe it was in September, a program in which we're looking, and I mean, they've talked about this for about the last 10 years, I should say, so we'll see what happens. But I'm hoping that it does speed up, and they increase the lack of lag time between starting talking about an FMS case and then actually getting the defense article. And then finally, I think technology issues and in-use monitoring. Again, in-use monitoring is going to be super important as we continue to increase the type of technology that we're providing to our allies. Historically, we kind of wanted to guard the technology that we were providing. We would give the asset, give the training, give the spares to help the life cycle, but we were reticent to give some of the technology know-how and things like that. Well, our allies are saying, hey, we're co-producing these things with you. We want to have the know-how. We want to make sure we understand that. So that's going to be an issue, I think, that forthcoming. This is a topic that, as Chris I teach a class with Chris and Alan. I could talk about the next 4 or 5 hours on, but I'm going to stop there. And I think there were some questions, Chris, in the chat function.
Okay. We were able to deal with several of those questions, Marcus.
Okay.
You see additional ones as they're coming up as Laura.
Okay. Yep. I will turn it over to you then, Chris. Yep.
Thank you for incredibly succinct and in-depth discussion of a very complex topic. So thanks very much, Marcus. Lori, what we'd ask Lori to do is talk about, as a senior person doing trade controls, asked to talk about some of the important issues that have to be dealt with as one is considering the trade controls and the export of technology abroad. Lori, the floor is yours.
As many of the panelists here have touched on, there are specific controls regarding U.S. origin technology, hardware, software, services that are included in the U.S. defense trade. And those trade controls, the regulatory structure is really bifurcated into 2 different areas. One is the International Traffic in Arms Regulations that governs the purely military type of defense articles, defense services, technology, and the Export Authorization Regulations, the EAR, that govern the dual use. Both of these components make up the military articles and dual use items that are covered by the Wassenaar Arrangement, joined by about 42 different member countries. So most of the European Union practitioners should be fully aware of the Wassenaar Arrangement and the definitional categories involved in the governing of military hardware and software and services. What the practitioner outside of the US and inside the US needs to know is that ITAR also has an extraterritorial reach. The US government tends to glom on to technology articles, defense know-how, defense technology, and continue to control that once it leaves the territorial borders of the United States, and attach additional obligations on the recipient of those technology elements, and control where they can go after the end user receives them. The ITAR in the regulatory structure and the EAR both contain license exemptions, areas where you don't have to go to the Department of State or the Department of Commerce to get a license. Those have been increasing because of the agreements that we've been reaching with our allies like the UK, Canada, Australia. There are a whole series of exemptions that exist to export technology, hardware, and services to those countries without a license. However, as in any export from the US, controls remain on those things once they leave the territory of the US. State, who is the governing body for the ITAR, maintains a policy of denial for entities and individuals on the sanctions list that Charles talked about. So make sure when you're planning on an export, you've screened the recipient of your data or your hardware so that you can assure that they're eligible to receive this stuff. There has been some flux with the Russian aggression in Ukraine to the policy of denial, especially in connection with Turkey. As we recall, Turkey a few years ago bought a Russian air defense system, which put them on certain sanctions lists for supporting the Russian defense industry. There has been some loosening of that policy of denial when Ukraine is the recipient of the ultimate technology and the end user for that defense hardware. The mission of the DDTC, of course, is to protect the national security of the United States, make sure that the best technology, the best stuff stays here or in the hands of only our allies and not the bad guys like Russia and China, as others have discussed here. Go ahead and go to the next slide, please, Chris. Some current and emerging issues, and Chuck talked about the derivative products issue. So when you have a US person performing defense services outside of the US, you have a deemed export of defense services. That person, that US person, is deemed to be performing defense services if they're working overseas for a military contractor. And that defense service must be licensed by the Department of State in order to continue. So if it is unauthorized and unlicensed by DDTC, it is deemed to infect the product that is the result of that defense service with ITAR controls. That's how you get the ITAR taint on what would otherwise be a purely foreign defense article. And then the Defense Department, the DDTC, wants to control that article that is built by the participation of a US person overseas. There are frequently asked questions on DDTC's website. I'll put those into the chat here in a bit on this subject, and they intend to further update their frequently asked questions with regard to this subject. We are anxiously awaiting those updates because at this point in time, what has to happen for a US person performing for a defense contractor overseas, they have to submit through DDTC's website and DEX for their authorization to perform those defense services. Historically, I guess defense contractors have assisted their employees overseas in submitting these general correspondence authorizations, but that's being discouraged because the DDTC wants to reach out and have a grasp specifically on the US person who is overseas and have them individually commit to the control of the DDTC over what they carry with them in their head. Of course, this raises privacy concerns, especially in areas like the UK, where you have the Privacy Act, in the EU, where you have GDPR, in Australia, where you have other privacy regulations, which preclude the employer even asking for citizenship data because of potential for discrimination. So you have a crosswalk here that you have to walk very carefully with regard to obtaining information on your non-US employees as to their citizenship. But it's you're going to risk ITAR taint if you're not authorizing your US citizens who are working abroad in performing defense services. And to show that this is an area of current enforcement, on September 7th, 2021, 3 former US intelligence officials entered into a settlement agreement with DDTC and DOJ regarding the unauthorized provision of cyber services to the UAE government. And it became a very significant step in DDTC's enforcement reach into US persons working abroad. Also to be aware of, the ITAR was recently updated on March 23. It didn't really undergo a significant change. It was just reorganized. So make sure that you're citing the correct DDTC and ITAR provisions in your licenses. Go back and check with the updated ITAR to make sure that your sites are all correct. Also, DDTC instituted several new open general licenses called OGELs. Those in the UK, those in EU should recognize what an OGEL is. It facilitates the legitimate defense trade with Australia and the UK and Canada with regard to the cooperation agreements. And it is a standing general license that can be cited for the export of defense articles and defense services. And with that, we'll give it back to you, Chris.
Thank you very much, Lori. This is like the moderator, careful what you wish for rule, which is I wished for an active chat and I've been trying to keep up with all my panel. So thank you very much, Laura, for a very nice review of these foreign controls. So with that, I think we've responded to the questions in the chat. Thank you all very much for your contributions to that, to the Q&A. Lori, thank you especially for a very nice review of this issue. If nobody else has any other comments, I'll sign off. This video is going to be available on Public Procurement International within 24 hours. Jessica Tillman helps me put it up. It'll be also available on the GW Law Government Procurement Law Program YouTube page. Be available there. And again, thanks to the panelists and have a wonderful rest of your day. And Kate, have a good evening. Take care. Bye-bye.